Okay. This is the third section of the paper on Nigerian women, discrimination against Nigerian women. And the title, the general title of the paper is Domestic, Regional and International Protection of Nigerian Women Against Discrimination, Constraints and Possibilities. The paper was published in 2002. And so there are details there that are specific to that time. There's a need to update, which I shall do when I get my next sabbatical, which is in 7 years. This section I'm going to read now is Discrimination Against Women, a Contemporary Overview. So while women in Nigeria have always been active economically, the extent and significance of their activism has not always been rewarded by commensurate degrees of political power vis-a-vis men. Although women willingly exercise the rights that they have, structural constraints from the pre-colonial, colonial, and decolonization eras continue to prevent the elimination of discrimination against them. It is possible to distinguish between two major positions by organized women's groups within Nigeria. One stresses more visibility in prominent positions for women as part of the decision-making apparatus, and the other calls for radical changes and structural transformation in order that the rights of all women will have as much de facto as de jure relevance. The first position constitutes the top-down approach held by the National Council of Women's Societies, and the second, the more comprehensive and broadly based approach, is that of Women in Nigeria, or WIN. Both organizations have made attempts to generate academic and other interest in the elimination against women, in the elimination of discrimination against women as they define it. Thus far, the NCWS, or National Council of Women's Societies, position has received more support from the successive Nigerian governments. The NCWS, working on the premise that with more women in positions of authority, women's issues will be taken more seriously and women's rights enhanced, advocates that there be more women appointees and that these women have more prominent positions. In response, the approach usually taken by Nigerian governments to correct discrimination is to appoint a few token women into positions where they have high visibility. However, let's be clear, this in no way helps the majority of women. Discrimination affects women's political and civil rights. The enfranchisement of women in the North was one of the political demands made by women's organizations in both the East and the West after their own enfranchisement. But the right to vote was only granted to women in northern Nigeria in 1976. In the East, it had been granted in 1954, and in the West in 1958. Some have argued that the exercise of this right may be problematic, even where it is guaranteed, because of social constraints on the movement of women in Purda in northern Nigeria. For instance, Professor Okome suggests that women who are secluded in Purda may be unable to vote as a result of electoral rules, which end the voting day at 6 p.m. because women in Purda cannot go out until after sundown. However, Olúfúnké claims that women in Purda turned out in such large numbers to vote in the 1976 local government elections, which were the first in which they could participate on an equal footing with men, that the voting day was extended by 2 hours. Thus, it is clear that women will exercise their rights with adequate and institutionalized protections. Women have also always exercised their rights as well as organized collective action within political interest and pressure groups for the enhancement of women's rights in society. Olúfúnké's work demonstrates that Purda in and of itself ought not to prevent women from voting, and there's no evidence that it has. Okome presumes that women who are not living under conditions of Purda would be better able to exercise their right to vote. This presumption is stated rather than demonstrated. Let's be clear also, some of the women who are not in Purda could be prevented from voting by familial pressure. And there's evidence that this has happened in Nigeria in elections. There's still fewer women running for office than men. And this situation hasn't changed, although, this paper was published in 2002, we're in 2023, and this situation has not changed. This situation of fewer women running for office than men is also observed in the United States and in most democracies. However, good citizenship necessitates the ability to free up some time good citizenship necessitates the ability to free up some time to participate in civic activities. More affluent or kin-rich women who have supportive extended family are better able to participate in modern democracies than impoverished kin-poor women who cannot depend on assistance from extended family. An additional problem that relates to women's ability to exercise their citizenship rights is that before Nigeria's 1992 constitution, only men could pass on their Nigerian citizenship to their spouses. The 1992 constitution corrected this discrepancy. Nonetheless, some rights may still be outside the grasp of women due to continuing social and administrative mores. Today, a woman who resides and works outside her state of origin is still discriminated against in employment, promotions, and benefits. This is a form of discrimination that affects men, women, and children because it affects access to resources that indigents of the state take for granted. And, Nigerian women supported 5 gender bills. In 2022, the Nigerian federal legislature did not pass the bills. They said they would revisit the matter. If they had revisited it and passed the bills, it would have corrected this problem, but we're still waiting. The Nigerian Constitution of 1979 prohibited discrimination on the basis of sex, as do the constitutions of 1992 and 1999. All women have a right to suffrage once they are above the age of 18 and can contest in political elections once above the age of 21. No customary prohibitions prevent women's participation in politics, but women have not contested for political positions on a level matching men. Women's hesitancy to be involved in politics dates to the period of decolonization, when politics was characterized by gross abuse and physical violence. Okome contends that Nigerian women do not have full legal capacity insofar as they are unable to independently enter into contracts, acquire and own property, enter into other legal transactions, sue or be sued, end quote. The extent of women's practical freedom also varies with class, level of education, and type of marriage. Within polygynous marriages, women may have more freedom than within monogamous ones because they are not subjected to the presumption of legal unity that is found in monogamous marriage, which gives the man the advantage. In terms of the capacity to marry, the right of consent, and the requirements of bride wealth payment, women's right to independent decision-making may be curtailed. In general, Nigerian law limits the right of a woman in marriage under all legal systems: the statutory law system, the Sharia system, and the customary law system. Nigeria, at that time, was undergoing the implementation of a structural adjustment program, or SAP, a program which combines policies of economic austerity with the devaluation of the currency, drastic cutbacks in government spending, and significant economic contraction due to the privatization of government-owned businesses. This affects the rights of all Nigerians, but women are particularly impacted. Women's economic rights are affected most directly since there are fewer employment opportunities and more competition for those that exist. In rural areas where development schemes have historically hindered women, technology and training benefits men more than women. The situation becomes more grueling under conditions of structural adjustment because due to a contraction of social spending and less money being available from international sources for development projects. Well, seems like history is repeating itself because these are the conditions that Nigeria is facing right now. Provisions for maintaining basic infrastructure, while inadequate in the past, became even more so after SAP. Again, history is repeating itself. Healthcare, education, training, access to appropriate technology, and to resources such as potable water became even more inaccessible both to rural and urban women. This is the background against which the existing discrimination against women in Nigerian society should be viewed. So let me now turn to discrimination against women, international, regional, and domestic protections. Discrimination against women persists despite the existence of international, regional, and domestic protections. This persistence is due to structural and ideological factors. The United Nations Covenants of 1966 provide protection against discrimination on the grounds of gender in Article 2.1, Civil and Political Covenant, and Article 2.2, Economic, Social, and Cultural Rights. The 1956 Supplementary Convention on the Abolition of Slavery, the Slave Trade, and practices similar to slavery, emphasized the importance of women's consent to marriage, and advocated the elimination of customs such as bride wealth and funeral rites in which women are objects of inheritance after the death of their spouse in Article 1. The 1962 Convention on Consent to Marriage, Minimum Age for Marriage, and Registration of Marriages considers some customs and traditions relating to marriage and the family, quote, inconsistent with the Universal Declaration of Human Rights, unquote. Nigeria is a signatory to the International Convention on Economic, Social, and Cultural Rights, signed on the 29th of July, 1993, and the International Covenant on Civil and Political Rights, or CCPR, signed on the 29th of July, 1993, too, as well as the International Convention on the Elimination of All Forms of Racial Discrimination, signed on the 16th of October, 1967, the Convention Against Torture and Other Cruel, Inhuman Treatment and Punishment, signed on the 28th of June, 2001. Also, the Convention on the Rights of the Child, signed on the 19th of April, 1991, and the optional protocol on the CRC, or the Convention on the Rights of the Child, on the involvement of children in armed conflict, signed on the 8th of September, 2001, as well as the optional protocol on the rights of the child, on the sale of children, child prostitution, and child pornography. This was signed on the 8th of September, 2001. Rights of production and reproduction encompass women's rights in the family and in the economic, social, and political spheres. Rights of production concern recruitment, promotion, and training, as well as benefits and entitlements. They also include equal opportunity for decision-making in all organizations. The rights of reproduction relate to the capacity for a woman to make independent decisions about her own body. This includes the ability to control the size of her family, exercise control over the discipline of children, free access to family planning, including abortion, and the right to legal and practical equality in the control of family resources and children after divorce. This is enhanced by a woman's access to information concerning her rights, as well as legal and other measures that can be taken to gain these rights. The rights of women within their families are important because they affect their ability to define themselves relative to society. Relations within the family structure the extent to which women are granted reproductive and productive rights. Defining the content of such rights, Article 5A of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, recommends that states parties, quote, modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and other practices which are based on the idea of the inferiority or the superiority of either of the sexes or on stereotyped roles for men and women, unquote. I have argued that the male-dominant elements of Nigerian society remain strong. Many of these elements are located within the family, where a woman is required to take care of her husband and home. Since most women also work outside the home, this creates a double burden and may limit the ability of women to devote an equal amount of attention and concentration to their careers and trade. In Nigerian law and administrative practice, the predominant attitude is that men are the household heads and have primary authority. This attitude persists in spite of past and contemporary examples of cross-gender cooperation in many households, and also despite the existence of many female-headed family units. Women thus continue to be defined just in terms of their reproductive and associated roles. Under statutory law in Nigeria, the woman must cook and care for the home and health of her husband and children. Problems reside in prevailing social mores, which prevent women from taking legal action even where fundamental rights are not granted. However, a more critical approach is necessary to discern the origins of these mores and to fashion workable solutions to the problems that they cause. There's also a gross lack of awareness among women about the extent and content of their rights. There are also legal and administrative measures which perpetuate the inequality of men and women within the family. For example, adultery is considered sufficient grounds for divorce only where women are concerned. If a man does it, then boys would be boys, is the attitude. And this is wrong. The CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women, guarantees full equality of men and women in the family. However, prevailing practice in Nigeria is to overlook customary and pre-colonial practices which prevent the achievement of full equality. While the government acknowledges, quote, the need for public enlightenment in the area of marriage and family law, unquote, by the time its first report to the Convention on the Elimination of All Forms of Discrimination Against Women was handed in, very little of substance had been done beyond the institution of a pilot legal project on family law. At the time when I wrote this paper, 2002, when the paper was published, 2002, there was a Women's Bureau, which was attached to the Office of the Presidency. Today, there's a Ministry of Women's Affairs. And a more aggressive stance was taken about improving women's status in society after the establishment of the Women's Bureau. And this was the process that kind of led to the creation of the Women's Ministry. Although the program was only a beginning and it had its own challenges, the Better Life for Rural Women program was directed at correcting some of the deficiencies noted in the first report to CEDAW. Really, one would have to look from 2002 till now to see what progress Nigeria has made on CEDAW. So that calls for an update for this paper. So since 1979, more women have formally competed for political office in Nigeria, but sadly today, in 2023, there are actually just about 4% women in our national legislature. The states are no better, and Nigeria really needs to do better on this count, because there are countries like Rwanda that have over 60% women in their national legislature. and many African countries that have met and exceeded the 30% recommendation by the Beijing plan, plan of action. So Nigeria, there's work to do on increasing the percentage of women in elected office, also in appointments to political positions. So at the time I wrote that there wasn't any legal recourse for women who suffer abuse within the family, although these were present during pre-colonial times. Well, today we have many efforts that are directed at correcting the problem of violence against women and girls, and there are even laws. So again, there's a need to update what this paper said. Now also, women's childbearing obligations are expected to outweigh their career goals. When a woman wants to pursue career and sort of downplay the childbearing obligations, the society is not very kind to such women still. In pre-colonial systems, women did not necessarily have to bear the brunt of childbearing alone. There were social institutions that provided support, and they enabled a woman to pursue her trade undisturbed. In contemporary times, women also suffer legal discrimination in the administration of custody law. The covenant, the UN covenant, provides in Article 16, 1D, that parents shall have equality of rights and responsibility with regard to their children, and that the interests of children should be given primary responsibility when custody matters are considered. Under customary law in Nigeria, the equality of the spouses is precluded sometimes as a result of great disparities in the age of the spouses, which gives the man more control over the wife. This also occurs in the case of divorce, where women are only entitled to custody prior to weaning, or in some cases, after the child is 7 years old. Under Islamic law, until the age of puberty or marriage. On a positive note, the woman has a right to claim maintenance from the father of her child, even if she's not married to the man. In some cases, divorce is only possible after bride wealth is refunded, although among some groups, deductions are made based on the number of children born by the woman during marriage. Again, there are developments that are encouraging in this respect, and the paper needs an update. In Nigeria, there's no guaranteed access to social security in old age provided by the government. So unequal access to and control over children in divorce imposes multiple discrimination on women, since they are expected to be primarily responsible for childcare. The Convention on the Elimination of all forms of discrimination against women guarantees women equal rights and responsibilities in marriage and at its dissolution. But some women are still affected in Nigeria by inequitable access to divorce. In Nigerian Muslim communities, divorce by repudiation is still acceptable. Under customary law, women have a right to support and housing, but not to the husband's property or income. Likewise, men have no right to their spouse's property or income. However, pre-colonial marriage laws allowed for conciliation and negotiation in the event of marriage breakdowns, which may have resulted in better treatment of the woman. In addition, A divorced woman could return to her lineage, where the head of lineage could grant her access to property. Under statutory law, a woman technically has equal rights with her husband to the custody and guardianship of children upon divorce, but the application of the law is often such that work within the marriage is not considered an economic contribution. Hence, there is no enforcement of maintenance payments. The crucial issue regarding the rights of women in marriage and the family is that these rights are central to their rights as individuals. The African Charter on Human and People's Rights in Article 2 prohibits discrimination on the basis of sex, but makes no other specific references to the protection of women's rights. Well, now we have the Maputo Protocol to the African Charter, which is the African Women's Bill of Rights. So it has improved on this situation. The scholar Howard argues that some articles in the African Charter may be taken as applicable to women, particularly Article 4 that specifies that human beings, well, quote, human beings are inviolable. Each is entitled to respect for his life and the integrity of his person, unquote. And Article 16 guarantees that every individual has a right, quote, to enjoy the best attainable state of physical and mental health, unquote. For Howard, both of these articles may be used for defending women against physically harmful practices. Women's lives also tend to be affected more profoundly than men's by their reproductive roles. When reproductive rights are lacking, rights in other areas are affected. In this sense, reproductive rights are not limited to the right to abortion. They also include a woman's right to employment and the means of production which allow her to financially support herself and her children. There is an observed conflict between community and individual rights, since the preservation of the family is considered the fundamental duty of society. Can the law be used as a means of transformation in this case? Howard considers this near impossible, but sees the role of law as enabling individuals who wish to escape from, quote, traditional, unquote, family controls to do so. The law in this sense would then be a building block toward the future realization of cultural change. Problems arise from provisions that may potentially pit the need to maintain community values against the rights of women. These may be observed in Article 18's specification that, quote, the family shall be the natural unit and basis of society. The state shall ensure the elimination of every discrimination against women, unquote. Article 17(3) considers the state instrumental in, quote, the promotion and protection of morals and traditional values recognized by the community. There is evidence of such a conflict in Nigerian government's first report to the Committee on the Elimination of All Forms of Discrimination Against Women. It argues that the constraints eradicating discrimination against women arise mainly from the lack of enforceable laws when women suffer discrimination from customs, administrative directives, and religious practices. The government at the time also lamented the absence of a favorable attitude toward litigation in Nigeria, which prevents the elimination of discrimination. What was left out in this part of the report, however, is the salience of a person's total environment in shaping that individual's perception of her or his possibilities and constraints in the wider society. It is doubtful that even litigation that results in positive acknowledgement of a woman's rights would amount to much without far-reaching social and structural changes. Altogether, there is inadequate acknowledgement on the part of the government of Nigeria on the significance of structural constraints. The government at the time had made insufficient provisions for the realizations of Articles 3 and 4 of the CEDAW recommendations. Article 3 calls for legal and extra-legal measures for guaranteeing the full exercise of women's rights. While it acknowledges the need for extra-legal perspectives, there is no concrete attempt by the government to address the imbalances arising from the conflict between individual and group rights. This still continues. The government identifies an absence of litigious attitude among Nigerians, which contributes to the appearance of a paucity of protections. This, however, is not borne out by historical evidence. For example, Nina Emma Mba shows that women in southern Nigeria used new family laws under colonial rule to support their claims in the legal system. Thus, it is more relevant to consider poverty as the crucial factor that prevents women from using litigation as remedies, as legal actions are usually very expensive and out of the reach of women who are poor and struggling. Article 4 of the Convention on the Elimination of All Forms of Discrimination Against Women calls for, quote, temporary special measures aimed at accelerating the de facto equality between men and women, unquote, in order to achieve equality of opportunity and treatment. Toward this end, at the time, Nigeria appointed the first woman vice-chancellor of a university and the first woman member of the Federal Civil Service Commission. Other nominal appointments of women were made mandatory at both state and government levels. But looking at where we are today shows that there's not been serious commitment to this kind of measures as a corrective to the problems that Nigeria has with including women equitably and having gender equality as, mainstreamed all through decision-making and policy-making and appointments. Okay, so notwithstanding these appointments, there's still evidence that women lack access to high levels of decision-making in Nigeria. There seems instead to be more evidence of tokenism, which does not recognize the extent of educational and professional achievement among Nigerian women. The government has also made some institutional modifications at federal and state levels, and women at the time were able to begin to take on bail individuals in police custody, subsequent to a directive by the Attorney General and Minister of Justice in Nigeria. However, the statement that women should, quote, bear any unpleasant consequence that may flow from that action indicates that there is still some perception among policymakers that women are not always entitled to protective legislation. Most legislative improvements concentrate on giving more access to urban elite women. Rural women were meant to benefit from the introduction of the Directorate of Food, Roads, and Rural Infrastructures, or DIFRI. The government's new master plan at the time for agricultural and infrastructural development to encourage higher rural productivity. Since the government realized that many rural women are farmers, they were targeted as primary beneficiaries of the plan. However, at the time even, the effort was believed to be largely failing. And really, if we look now, it is doubtful that Nigerian rural women farmers are doing substantially better and substantively better than they were in the early 2000s. Chapter 4 of the 1979 Constitution of Nigeria contains, mind you, we now have the 1999 Constitution, I'm aware, but so follow me, I'm kind of trying to make a point. So Chapter 4 of the 1979 Constitution of Nigeria contains provisions for the defense of the fundamental rights, human rights of all Nigerians. Provisions for the protection of individuals from discrimination are to be found in subsection 39, which provides that a citizen of Nigeria of a particular community or ethnic group, place of origin, sex, religion, or political opinion shall not, by reason that he is such a person, be subjected either expressly by or in the practical application of any law in force in Nigeria, or any executive or administrative action of the government to disabilities or restrictions to which citizens of Nigeria and other communities, ethnic groups, places of origin, sex, religions, or political opinion are not made subject, or C, be accorded either expressly by or in the practical application of any law in force in Nigeria or any such executive or administrative action, any privilege or advantage that is not accorded to citizens of Nigeria of other communities, ethnic groups, places of origin, sex, religions, or political opinion. This section of the 1979 Constitution, in effect, provides for equal treatment of women and men under the law. According to the Nigerian government's report to the Committee on the Elimination of all forms of discrimination against women, there is no need to create enforcement mechanisms for the convention because its provisions could be used as the basis for any argument against derogations in any court of law within Nigeria. The same report states that while protections exist, there may be no progress toward the elimination of discrimination if women do not actively pursue the realization of this goal. However, the argument that it is up to women to seek legal redress may be a straw man because without the right tools and considerable governmental support, such active pursuit of women's rights may be impossible. Discrimination in property ownership still exists under customary law. While everywhere women are entitled to property acquired by trading, antenuptial property belongs to both parties in the north and east, but only to the husband among the Yoruba. Once divorced, the woman is not entitled to her husband's estate. The Convention on the Elimination of All Forms of Discrimination Against Women in Article 16(1)(h), considers both spouses as having the same rights in respect of the ownership, acquisition, management, administration, enjoyment, and disposition of property. The report of the Nigerian government states that the same standards apply to both married and unmarried women in the allocation of government-owned land and housing. It identifies customary law as the main avenue of discrimination in property ownership. This is not only inaccurate, it constitutes a refusal to acknowledge that the majority of women who apply for government-owned property are often educated, wealthy, well-connected, or based in urban areas. Also, these women are most likely to invoke CEDAW and take legal action against discriminatory practices. The government's report fails to acknowledge the vital role that family negotiation plays in customary law to militate against abuses. Consequently, poor women living in urban areas suffer because kinship ties become more tenuous under conditions of urbanization. Women in Nigeria also suffer legal discrimination in the control of contraception. Couples should be entitled to the fundamental rights, human rights of freely and responsibly determining the number and spacing of their children. According to Article 12(1) of the Convention on the Elimination of all forms of discrimination against women, state parties shall take all appropriate measures to eliminate discrimination against women in the field of health care in order to ensure equality of men and women in access to healthcare services, including those related to family planning. However, the contemporary practice in Nigeria is to deny women access to contraception by the Planned Parenthood Foundation of Nigeria. I mean, that was 2002, mind you. If they did not have the signed consent of their spouses. At the same time, contraceptives can be acquired over the counter and without any medical advice or monitoring. This is a double standard, which denies that women were competent to make independent and responsible decisions. The control of reproduction in that manner is indicative of society's conception of the locus of power within the family. This can be linked to accepted indigenous methods of contraception, where women are expected to periodically abstain from sexual intercourse, while the polygynous man has no such obligation. Abortion is also legally and socially controlled. There are strict prohibitions against abortions in Nigeria, which date from the English Offences Against the Person Act of 1861. This was the source of the colonial regulation of abortion, and it remained in force in Nigeria at the time this paper was published. The only condition under which abortion is permitted by that act is if it was performed in good faith and for the preservation of the mother's life. Again, there needs to be an update to see what the situation is in Nigeria right now with abortion. Under sections 228 to 230 of the Southern Criminal Code and sections 232 to 236 of the Northern Penal Code, abortion was considered a crime, punishable by varying terms of imprisonment. The 1975 UN report on the status of women and family planning suggests that abortion should be legalized, since unjustified state interference with regard to abortion is likely to not only be socially repressive and discriminatory, but to be personally traumatizing in its effects. This is especially true as it affects women's attempts to gain autonomy over their bodies. Some of the key issues surrounding abortion are whether a woman is considered competent and whether she is considered to have the capacity to make independent decisions about her body. The 1976 recommendation of the Nigerian Medical Association and the Society of Gynecologists and Obstetricians of Nigeria that the government allow abortions on request for health and welfare reasons was not approved by the federal government because of considerable opposition from some religious authorities. And I dare say the religious authorities in Nigeria still continue to vehemently oppose abortion. The Nigerian government was wrong in assuming that the main roadblocks to the elimination of discrimination are extra-legal. Legal and extra-legal constraints coexist in both the letter of the law and its administration. It is generally acknowledged that customs and traditions still persist, which prevent the elimination of discrimination against women. And also that positive action must be taken by women to attain the full enjoyment of their rights. What is usually not addressed is the provision of practical measures through which women can, if denied their rights, gain support toward the granting of these rights through legal and organized political action. Another source of discrimination is to be found within the practice of religion. In both Christianity and Islam, there is a presumption of the inequality between women and men that did not necessarily exist in pre-colonial religion. In spite of Islamic provisions for the equality of all believers, purdah and polygyny are considered obligatory. Since peasants cannot afford to seclude their wives, these phenomena are linked to class. In Christianity, the orthodox position is that women should be submissive to men. Women's restricted access to information in Islam likewise encouraged them to accept a submissive role. Even in the case of Christianity, education and a reconceptualization of the role of women is necessary if significant progress is to be made. Any prescriptions or conditions that may be found in the definition of the role of women in the Bible remain inadequate as the sole harbingers of change. Both religions contribute to the continuation of discrimination against women. Under colonial rule, education was not widely extended to women, and where it was, women were prepared for predominantly domestic roles. This is reflected in the lower percentage of women in all professions and academic subject areas. Article 10, sections A to H of the Convention on the Elimination of All Forms of Discrimination Against Women makes detailed provisions for the guarantee of equal rights for men and women in education. However, in 1975, female enrollment in elementary schools was 32% for 6 to 11-year-old children and 14% for students 12 to 17 years old. From 1975 to 1976, female student enrollment in universities was 15.9%, and in 1981 to 82, 27.96%. The Nigerian National Policy on Education, according to the report, makes only the following reference to women's education. And this is a quote: "With a view to correcting the imbalance between the number of boys and girls in formal education, and with particular regard to women's education, special effort will be made by ministries and local government authorities in conjunction with ministries of community welfare and of information to encourage parents to send their daughters to school." The particular form that's, okay, so that's the end of the quote. The particular form that such encouragement would take was not specified. The government considered that adequate because the 1979 Constitution provides in Section 18, paragraphs 1 and 3, that equal and adequate educational opportunities at all levels will be ensured, and that free education at all levels will be provided when practicable in order to eradicate illiteracy. One wonders whether Nigeria is serious about this, because the country currently has some of the largest numbers of out-of-school children in the world, over 12 million. So while in the 1970s and early 1980s, education was free at all levels, the cutbacks in government spending following structural adjustment negatively affected education as well as other policies. And actually, I think at the time in some parts of Nigeria, Eastern Nigeria, the pendulum swung towards girls. More girls and women were becoming educated at the higher levels because the men were going into apprenticeships, which were more likely to provide them with jobs that they could make an income from. Okay, so education was free at all levels in the 1970s and 80s, but the cutbacks in the government spending following SAP negatively affected education as well as other policies. Equal employment opportunity and associated rights are provided for in Article 11 of the Convention on the Elimination of all forms of discrimination against women. And the Nigerian Constitution of 1979 also provides that the government endeavor to ensure, quote, equal pay for equal work without discrimination on account of sex or on any ground whatsoever, unquote. Nigerian women have a high level of participation in economic activity, but men still largely control the commanding heights of both politics and the economy. Thus, while women are represented in all the professions, as well as in farming and trading, there's a concentration of men in the high levels of government, as well as in the private sector. The problem in terms of equal employment opportunity, therefore, concerns underrepresentation in decision-making rather than non-representation in the professions and the decision-making. All women in the workforce face a double burden of work, which tends to restrict their chances of upward mobility vis-a-vis men. Some employers who consider men more stable for employment also discriminate against women, as does the government in the administration of laws on taxation and employment benefits. It is clear that the primary responsibility for domestic labor still falls on women, despite the provision that, quote, parents share the same rights and responsibilities by Article 16, 1D of the 1979 Covenant. Until men and women bear equal responsibility for household labor, women will have limited access to employment opportunities and upward mobility. Also, there are very few women in positions of authority to make meaningful decisions regarding the rights of women. An additional problem is class. Women do not always share common interests, since human rights have different implications for poor and affluent people. Class and sectional differences, therefore, may prevent cooperative collective efforts by all women to gain the rights due to them. Another problem is that people have deep psychological ties to their culture and customs, and many women may prefer to live, and quote, many women may prefer to live under those customs with which they are most familiar, even though the customs deny them personal freedom, unquote. When these women choose to take concrete steps towards gaining their rights, they also face some degree of social alienation. Education must therefore be directed at women as well as the whole society to foster the elimination of discrimination against women. The personal rights of women to exercise control over their bodies is limited also by female genital operations, which in some cases create medical problems, including maternal and infant mortality, especially when combined with pregnancy at too early an age. These practices violate both Organization of African Unity, and you can see this paper is old because now we have the African Union, and United Nations principles on basic human rights. The Economic Commission for Africa also condemns them, but rightly pinpoints the complexity of the situation. Considering the aforementioned role of culture in the lives of people, these and other abuses are only eradicable over the long term. When women themselves find no use or rationale for these practices in their lives, they will disappear. Without such a commitment, efforts that are directed at eradication could prove to be fruitless. Another facet of the inability of women to exercise independent control over their bodies relates to the role of culture in the exercise of social control over individuals. Insofar as women as a group are in a subordinate position to men, one could agree with Howard that such control is directly beneficial to men economically, culturally, and politically, with a caveat that women themselves share the thinking that these practices have some validity to their lives. So this is the end of this section, and the last section would be the conclusion. So to be continued. Thank you.